All right, well, I'd like to thank all of you for joining us today. Today, Kristin and I are going to be discussing your estate planning toolbox. And we're going to be discussing some things that would be, you may have in your toolbox already, or things that if you don't, you might need to think about as you prepare for the second half of life. And as Matt mentioned, my name is Landon Hodges. If you hear a little bit of a Southern drawl, I'm originally from Mount Airy, North Carolina. I went to Wake Forest University in Winston-Salem for my undergrad, got my law degree from Elon University, and I practiced in all levels of estate planning, but primarily in wealth protection and tax planning. But I also do some long-term care planning, real estate matters, and litigation as well. So if you have worked with me, I'm glad to see you here. And if you have not, give our office a call, and there's a good chance that you'll probably be running into me at some point. Currently, I reside in Jersey Shore, Pennsylvania. So between our State College and our Williamsport offices, I kind of position myself in the middle to make sure that I can reach both offices if needed. So I mentioned my hometown of Mount Airy, North Carolina, and that probably doesn't ring a bell to many of you. It's a small town near the Virginia border. But what some of you may know it as is this town was Mayberry in the Andy Griffith Show. Now, my original idea was that, hey, Andy and Barney could use a young lawyer there to deal with, maybe Otis got arrested again or anything like that. But, well, they decided they did not need a young attorney in that show. So I like to say I was cut from the original cast. But if you need any memory techniques for me there, just know that yes, that I am from the original Mayberry, I suppose, small town in North Carolina. And all right, and with me today is Kristin Daugherty. I'm going to turn it over to her to let her introduce herself.
Okay, thanks, Landon. Good afternoon. I'm so excited. I do a lot of presentations at the firm, but Matt's right. This is my first virtual one, so this is really exciting, and I'm happy to see so many people joining us today. As you'll find out, I like to talk, so this is great. So I actually am local. I graduated from Lycoming College. Before I joined the firm, I've been here for about 8.5 years now. I actually worked for the Area Agency on Aging, administering the waiver program. I am a long-term care planner here at the firm. I'm also a certified Medicaid planner. So I work with families that are in the planning process and primarily really working with families who are in crisis. So if they have a loved one that needs care now or in the near future, I'm the person that's working with you to navigate through that process. Hey, thanks, Landon. I'm also a certified dementia practitioner. And earlier this year, before COVID, I traveled to Arizona and became a certified Alzheimer's disease and dementia care trainer. So our firm has really taken the path to make sure we're focusing on dementia and dementia planning to make sure that we can help everybody to the best of our ability and really be able to be that one-stop shop when your loved one needs care. So I think that's enough about me. We'll jump right into the presentation. Landon's going to start us off. Landon's actually going to take a large chunk of the presentation today because we're going to be talking a lot about legal documents. I'm going to jump in the middle of the presentation, talk a little bit about planning, and then Landon's going to take us home, I think, and end talking about trust. So Landon?
All right, well, thank you, Kristin. And yep, so you're going to hear a lot from me today, so hopefully that's not too bad, but I'll try to make it as interesting as I can because I understand some people don't find this as interesting as I do, but hopefully should be a good and informative and hopefully entertaining discussion for you. So as I mentioned at the beginning, we're going to discuss what's in your estate planning toolbox. And so let's start with the basics. So what types of tools would go into this toolbox? And for your estate planning toolbox, we're talking about the legal documents that provide the basis for your estate plan, both while you're alive, determining who would be your decision makers if you're not able to, and then of course after your death with a last will and testament. We'll discuss a little bit about each one of these, and I'll give you some tips to make sure that if you have existing documents, that you'll know what to look for to see. And of course, we'll go over and discuss the ins and outs of each one and how they all fit together to make sure that you have a toolbox that allows you to be prepared for whatever might come your way. And just a note about estate planning generally, estate planning is the documents that might go into your toolbox are just as individualized as your particular estate. What you have may differ from someone else because each individual has their own interests that need to be addressed. Your goals determine what would be best for you, and our job is to work with you within your goals to ensure that you have legal documents in place that would carry forward what you want to happen either now or in the future. All right, and so as I mentioned, your goals determine what is going to be best for us to do. We want to organize your estate affairs, but then beyond the basics, and I'll talk about this when we get to trust a little bit, there are ways to protect assets to ensure that if you ever need nursing home care, that you're not going to lose a great deal of all the assets that you've worked your entire life to amass. We want to make sure that upon your passing, there is something to the next generation, because at the end of the day, these are your assets and you've worked hard to get them. So we want to work to protect them as much as we can. And then also, of course, assume even if you don't even need nursing home care, the time's going to come for everyone eventually. So we want to make sure that there's a plan in place that upon your passing, all of your assets get distributed among your spouse, your children, anywhere you would like it to go. Because as I tell people all the time, if you don't have an estate plan, the state's written one for you. So it's good to make sure that you have a say in the matter as to what happens to all of your assets when you pass. So getting into the specifics, we're going to talk about 4 essential tools that should go into this toolbox. The first one is, let's start with the basics. The basics, and no one meets with me in my office without me making sure that you've at least received a strong recommendation to have the basics. And the basics are powers of attorney and wills. I cannot stress that enough. These are important for everyone to have. And so powers of attorney, our office does 3 different types of powers of attorney. Now you might see it formatted differently and you might see some things combined into different documents. The structure and the formatting of it is not as important. If you did it with another law office, it might look different. That's okay. What's important is that it has all the powers that your agent would need. So we use financial, healthcare, and mental health powers of attorney. I'll get a little bit more into detail in each of those. But then there's also similarly to the powers of attorney, there is a living will, and then of course your last will and testament. So when I say the basics, I'm really talking about all of these documents that, regardless of the size of your estate, the size of your family, or the complexities that go into it, these are very important to have. So arguably the power of attorney is the most important one of them all. And this is the one that determines who would be your decision maker while you're alive if you're not able to handle your financial or health care matters. So the legal definition is that it's a written legal document where you, the principal, authorize another person known as an agent to be able to act on your behalf. Now, of course, what's most important with these documents is that you trust whoever you name on there, because the financial power of attorney, for example, authorizes your agent to make any financial decisions for you. And it's important to have, because if you can't do this, you want to make sure that someone can. But again, going back to that theme of trusting this person would have the power to open and close bank accounts, sell real estate, defend in litigation, make gifts from your assets, or to create a trust for your benefit. And now, if you do have documents that were not done by our office, and if they were done by our office, then you can be assured that this specific language is in there. But if you have not, have a look at it and see, because 2 powers that I always want to point out with a financial power of attorney are the power to make unlimited gifts and the power to create an irrevocable trust. The reason that those 2 are important is because if you were to become incapacitated, or if you were to need nursing home care and you're working with Kristin in order to organize your assets to receive as much benefits and save as much as possible, one of the things we're going to need to do is get assets out of your name. So gifting is important. And if it does not say the word unlimited gifting, it is limited to whatever the IRS gifting exclusion is every year. Currently, that's $15,000 a year. Now, that's a lot of cash, but if we're talking about real estate, if it does not say unlimited gifting, your financial power of attorney does not have the power to get real estate out of your name to protect it if needed. Similarly, a common way to protect assets is by using irrevocable trusts and then gifting the assets into them. Without a specific power saying that your agent has the ability to create an irrevocable trust, you do not have that power, and your agent does not have the ability to create a trust for your benefit that would be able to protect assets from creditors and the cost of nursing home care. So while it's important to have a comprehensive document, these are two that you have to have specific language in there to have it. And if you don't have it, and if there were, Lord forbid, a healthcare crisis, and you're meeting with Kristin, we're going to be looking for those particular powers. And if you don't have them, we're going to be hopefully able to update them and sign new powers of attorney, or in a worst case scenario, have to go through the court system to get a guardianship in order to get those powers. So that's a few things to keep an eye on there. If you have older powers of attorney, so there was a law change effective January 1st, 2015, that changed the notice on the front of that document. Now, older ones are grandfathered in. So if you have one that's older than 2015, it should still be good. But I've run into issues with some of my clients that had older ones where banks were not respecting them because they don't look the same as the ones that are up to date with the current law. So if you have one older than 2015, I would recommend giving our office a call or speaking to an attorney to get those updated, just to ensure that you're not given any trouble if you ever have to use it. All right, so that's the financial one. So that's all I'm going to address for that at this time, but of course I'll be here for questions afterwards. But the next one is a healthcare power of attorney. Now, this is one that if you go to the doctor's office, you've probably been asked if you have a healthcare power of attorney or a healthcare directive. These terms mean the exact same thing, whether it's called an advanced healthcare directive or a power of attorney. What it really is doing is it's a document in which you appointed someone to be able to make medical decisions on your behalf if you're not able to. So this can cover things such as consenting to surgery, admitting or discharging to hospitals or nursing homes, and very importantly, reviewing medical records. Because without this document, there's a chance that you might be told that you can't go into the doctor's office with a person or receive any information about their medical file. So this document allows you to have the information that you would need, and if you personally are unable to make a medical decision, whether that's due to a mental inability to do so, or if there's been an accident and you're unconscious, this lets your medical providers know who would be the point of contact to make those decisions. Very important to have, because you certainly don't want there to be a question of who's making a decision if you need emergency medical care. Now, living will is also known as a healthcare directive. So if you see healthcare directives, a lot of times it takes the healthcare power of attorney, the living will, into one document. Again, that's not wrong. It's not invalid at all. We personally split them into two separate documents because they are activated at different times. So the living will is specifically dealing with end-of-life decision-making. It allows you to express your wishes for what you would want in the event that you are in a terminal condition, you're in an irreversible coma or a vegetative state, and your doctor feels as though there is no chance that you could recover from that condition. And one way I explain this one commonly is, of course, it's not on the slideshow because it's not the legal term for it, but you might hear this referred to as the pull the plug document. But what's most important here is that you have something in place that details what your wishes would be, because if you were to ever be in an irreversible coma, this answers questions such as, would you want hydration, a feeding tube, breathing machine, surgery, you name it. This document allows you to say that if you are in an irreversible coma with no chance of recovery, you would like to be made comfortable, but allowed to pass away naturally without being artificially sustained on a feeding tube or something like that. It's a very important document to have because most people feel strongly about one way or another about what they would want under those circumstances. And then, well, I kind of got ahead of myself there on the slideshow a little bit, it looks like, but this is something that if you feel strongly about it, you want to make sure that you have this in writing so that under those, again, we don't want anything left up to the imagination. So this allows you to put your wishes in writing to ensure that your wishes are carried out when the time comes. The last of the types of powers of attorney that we use is a mental health power of attorney. So that's newer. It was only created by our legislature in 2013, but it's much more treatment-based, and it allows your agent to consent to types of treatment specifically for mental health services that may not be covered under your healthcare power of attorney, such as an experimental drug or a trial study. These can be very useful for mental health treatment situations, and having all of these types of powers of attorney together greatly reduces the chance that if you are unable to make your own decisions, that your agents are ever going to be told that they don't have the power to do something that would be in your best interest. With all of them together, you should be covered, and if you're not able to do it yourself, your agent should be able to step into your shoes and make sure that you're taken care of. So one question that I get is, well, if I'm married, why do I even need a power of attorney? You have a spouse, and it's very common to assume that your spouse automatically has the power to act on your behalf. Now, of course, that's true for anything for joint accounts, because of course, if it's a joint account, you're a joint owner and you have the power to access anything like that. But the law does not assume that your spouse can act on your behalf for anything that would be in your individual name, or especially something like, as I discussed earlier, making a gift to reduce your assets or to create a trust. Even with your spouse, it's advisable to have a power of attorney in place to ensure that it's in writing that they have these powers. Because otherwise, again, if you don't have powers of attorney, or you have powers of attorney that aren't comprehensive enough to cover what you might need, then the only other step, if you or a loved one is incapacitated, is a court-ordered guardianship. Now, that's a lot more money up front because, of course, it's a lot more expensive to get a court order or go through a court process than it is to sign legal documents. But also there at the bottom, if you or a loved one is already in a nursing home and you're having to do this now, the average cost of nursing home care is over $10,000 a month. And it takes about 3 months to get the court process done. So if you do that math, in addition to the extra cost of having to go through a court proceeding, it could be over $30,000 of nursing home bills spent up just while we're waiting to get in front of a judge. So all of that can be prevented by having good powers of attorney signed prior to the crisis. And that's why it's very important to have powers of attorney in your toolbox as you move forward. So the bottom line is, as I mentioned earlier, you have the ability with these documents to choose who makes your decisions and what your estate plan looks like. Otherwise, it's going to be put into the courts and it'd be a lot more of a process than it would have to be. Now, so your powers of attorney, they cover all decision-making while you're alive. Now, as soon as you pass away, your powers of attorney are no longer good. And what's left is your last will and testament. You're probably familiar with these documents, but this is a written instruction about how your property is going to be distributed upon your death. Similar to a power of attorney, you will appoint an executor or a personal representative. Those are in quotes because they mean the exact thing. That's the exact same thing. Unfortunately, lawyers like to use different terms and they all mean the same thing. It's annoying, but it's something that happens in all areas of law. But so executor, personal representative, it doesn't matter which one. It means the same thing. And that's the person that will step into your shoes after you pass away to make sure that your estate is administered. So think about who would be best to take that role, because there is work to be done. And you want someone that you're going to trust to do it and will have the time to do it. And so your will is going to cover any assets that are left in your name when you pass away. Now, one thing to be aware of is what we refer to as a will substitute, because any asset that has a beneficiary designation, so commonly you see that on life insurance policies, your retirement plans, maybe an annuity that you have, even a transfer on death account. If you have a beneficiary designated on an account, that acts as a will substitute, and that asset will be distributed as the beneficiary is designated on the account, regardless of what's in your will. So for example, if you have your beneficiary set up from 20 years ago and somebody's either died or maybe circumstances have changed and you no longer want that person to be your beneficiary, a lot of times people will meet with me or another attorney and update their will to cut someone out or to make the changes. Well, if you don't go back and change your beneficiary designations, it doesn't matter. Your beneficiaries will receive that asset when you pass away, and it doesn't matter if your will says, I hate this person and they're not to get anything. That doesn't matter. Beneficiary designations always win in that situation. So be aware of any accounts that you have that might have beneficiary designations, and know that just changing your will is not always all that you need to do to make sure that your distributions are done correctly. And also types of ways of owning property, such as joint accounts, or if you hold real estate as joint tenants with right of survivorship. Those types of things automatically transfer to the joint owner upon your death. So with a joint banking account, that's the easiest example. A lot of you are probably married and have accounts jointly with your spouse. In that case, that's a will substitute, in that when one spouse dies, that account automatically belongs to the survivor, and it did not have to go through their will to do it. Same thing with real estate. If you own property jointly, either as a married couple or with right of survivorship, it's the same deal. One of you passes away, the surviving owners automatically take it regardless of wills. But watch out for that in deeds, because if it's just two people that aren't married that own property together, or if it says tenants in common without anything else, then the default under the law is a tenancy in common, which would mean that each person who owns a portion of that real estate, it would go through their will. So to make matters more complicated, I guess, if you're thinking about changing the way your estate's distributed, you need to look at your will, your beneficiary designations, and the deeds to any property that you own, because those three things could each independently determine how they're distributed upon your death. Now, of course, if you're working with an attorney, and especially with our office, we will be looking at all of that, but it's important to know, especially if it's been a while since you've looked at these types of things. And again, I keep getting ahead of myself a little bit, but now there are worse things to do. But beneficiary designations, again, a lot of accounts allow you to designate on the account who gets it. And I think these are advisable because it's much simpler, much more straightforward. And there's sometimes some tax advantages to it. But if you're able to make these designations, I would recommend that you do so. But of course, be aware of who it is, because if you ever want to make changes in the future, you're going to need to change these designations in addition to your will. All right, so important point number 2. So that the first one, that was just the basics. Number 2 is special needs planning. This is another area of law that our firm specializes in, because it's very similar in the documents, at least, to planning for a person's estate and planning for the second half of life. Because if you or a loved one have a child or another loved one with special needs, there are documents in place that can ensure that they have decision makers, and that upon your death, any portion of your estate that you would like to leave to a person with special needs can remain protected in the event that they are receiving any sort of public benefits, whether that's income, housing, or medical insurance. There are ways to ensure that you can pass money to these people without it jeopardizing their standard of living or their benefits. So this is something that can be done either on behalf of the person with special needs, or most commonly, or best case scenario, it's done with the person with special needs' parents or guardians as they're doing their own estate planning. Because this type of planning can ensure that they do get an inheritance and they can preserve any benefits that they are having. Now, there's multiple ways to do this. And I'm not going to go deep into these types of trust. I will spare you that much fun for now. Because this is a topic for another time. This is a very in-depth topic that I have spoke on in the past. Just know that if you have questions about this, please do give us a call, because you're certainly not stuck on your own, and there is something you can do to ensure that this type of planning is done correctly. But as a quick introduction, a third-party special needs trust is a trust that can hold money for a person with special needs that's not counted as their resources for purposes of public benefits. The third-party part of it means that it is established by someone else to be funded with their money. So previously, I said best case scenario, this type of planning is done by a person with special needs as parent or guardian. A third-party special needs trust is the type that you would establish for a loved one, so that when you pass away, your money goes into this trust instead of being paid to the person directly. Now, similar to that, a first-party special needs trust works the same way. It protects assets from being counted for purposes of benefits. But the first-party part of it means that it's established by the person with special needs with their money. So you see this if a person with special needs maybe is receiving Medicaid benefits, and then a well-intentioned grandparent, for example, leaves them some money in a will. So say it's $20,000 as an example. That is a great money and a great gesture, but that would put them over the limit to qualify for several benefits. And while it's a great help and it's very appreciated, that's not enough money to live the rest of your life on. So something would need to be done. A first-party trust is a type of trust that money could be put into to be there for their benefit, but not count towards those asset limits. And now the downside to this type of trust is that it does require that upon the person with special needs' death, anything in there does get paid back to any state that provided Medicaid benefits for them, which is why it's not as preferable as a third-party trust. But if it's lose benefits now and have to reapply later, or set up this trust and have it there, this turns out to be the best case scenario. And then for smaller amounts of money, there are pooled trusts, and basically that's a first-party trust, but it's administered by a nonprofit organization that keeps all money that they are managing in a pool with separate amounts, for you. So if you put $10,000 in there, it's invested as a pool with everyone else's money, but they know how much you have, and that nonprofit organization will keep your separate share and manage it and manage it for you and ensure that you have distributions for your needs. But as opposed to the other two, this is managed by a nonprofit organization, and you don't have as much ability to choose who would be the trustee. So that's the types of trusts that are used in special needs planning, but any of them are very instrumental in ensuring that money can be set aside for a person with special needs without ever becoming their countable asset for purposes of benefits. Now, one new tool for your toolkit in the realm of special needs planning is an ABLE account. So this is under the ABLE Act. Pennsylvania just did this within the last couple of years. I can't remember exactly when right now. But if a person was determined to be disabled before age 26, they can set up an ABLE account. Now, information about ABLE accounts and links to set up an account is at www.paable.gov. That's a government website directly through the Commonwealth. This type of account is owned by the person with special needs, but can be used similarly to a trust to ensure that that money is there for their benefit, but does not affect their eligibility for benefits. Now, the downside to an ABLE account and why you see trusts used in a lot of situations is that you could only put a maximum of $15,000 per year into the ABLE account. And so if you have a windfall or you have a larger sum of money that you need to deal with, then this is not going to be preferable. But for smaller amounts of money, these accounts are easier to set up and cheaper than trusts, and also allow the beneficiary some control over the account that they may not have otherwise. But there are asset limits there, and if you have questions, it would be good to consult with our office about that. And then there's your number. So yeah, $15,000 is the most that can be put in there at one time. If a person is receiving SSI income, they can only have a maximum of $100,000 in the account total. Otherwise, you've got over $500,000. So at $15,000 a year, you can add to this thing for many years. But typically the money's there and it's being used. But just know that this is one of the potential tools that you could have if you are planning for a loved one with special needs. All right, so number 3 is long-term care planning. This is Kristin's bread and butter, so I'm going to turn it over to take over from here.
Thanks, Landon. Okay, we like to make sure nobody's taking a nap, especially right after lunch. I know it's very tempting. So I'm going to spend a few minutes talking about long-term care planning. We actually do entire seminars that focus completely on long-term care planning. So I'm just going to dip into it a little bit today. Really, when it comes down to it with long-term care planning, everything Landon's talked about so far and what he's going to talk about at the end of the presentation is essential for the long-term care planning. You know, a lot of times when I'm having meetings with new clients, or now virtual on the phone or Zooms, you know, they want to dive right in because they're worried about, you know, mom or dad or their spouse that just moved into a nursing home and they want to protect assets. And that's absolutely what we're going to do. But as Landon mentioned, we can't do any of that unless you have really good legal documents in place. And there's nothing worse than somebody who's already in a nursing home. The family's already paid that first $10,000 to the nursing home. And then we have to say, wait, we have to do a guardianship now because their power of attorney is not good enough and they don't have the ability to sign a new one. So before we can even protect assets, we have to go through the court process, and that could take 3 months or more. So, you know, making sure that your legal documents are in good order right now is the best thing that everybody can do. And, you know, as Landon mentioned, I know we'll talk about again, our office offers free initial consultations. And we do that because we want to make sure that we're doing a good job for you. We want you to come in, you know, in a very informal way, have a conversation with us, and we'll let you know what you need to do. If your documents are in good order, great. If they're not, let's get them updated right now. So when the crisis hits, whether it's care or you pass away, everything's in good order because nobody wants a mess, you know? So when we're dealing with long-term care planning, really what that is protecting assets. So it's implementing strategies to make sure that you or your spouse don't become impoverished paying for care. It's really a process, and there's a lot of different ways to do it. And it's not about hiding your assets, it's actually about protecting them for your spouse or for future generations. So a question I get asked a lot is, well, is this legal? Can we do this? Yes. I feel very strongly, I love all my clients I worked with, but I'm not going to go to jail for you. So I'm going to make sure that everything we do is done in a really good way and it's done in a legal manner. Landon, you can go to the next one, thanks. So Landon's controlling for me now, so we'll see if he can keep up. So as Landon mentioned earlier, you know, the average cost of skilled nursing home in Pennsylvania is over $10,000 a month. It's actually creeped up to $10,732. And that's, I think, a really fair average for our areas. I see some skilled nursing homes, you know, still about $8,000 a month. And I've seen some that are up to $13,000 a month. So it's really scary. And it's easy to see how your entire life savings could go towards your cost of care very quickly. There's different levels of care. So we often focus on that highest level, that skilled nursing, because it is the biggest threat. But there are other facility levels of care, such as an assisted living, otherwise known as a senior living facility or a personal care home. They provide fantastic services also. They really range in the cost of care. Some of them can still be about $4,000 a month. I've seen some up to $9,000 a month. It really depends on the facility and what all they're providing. Generally, with that level of care, there's a base cost, and then based on how much more care you need, they add on to that. Some of these senior living facilities now provide memory care, which is great, but you are going to pay for it. It is going to creep up there almost to the cost of nursing home care. One of the differences that we aren't really going to dive into in this seminar, but really is, how do you pay for those costs of care? When we're talking about assisted living, personal care, senior living, it's pretty much out of pocket. So you're going to pay it every month. You're going to get a bill. The same is true for that skilled nursing home. However, there are ways to qualify for Medicaid, which is a lot of what we do here at our firm, is working to protect assets to qualify for Medicaid. So the best strategy is planning. So we're going to talk here in a few minutes about the 5-year look back, because that's really important and it's really confusing, and I always want to make sure we have the right information out there. But planning ahead is always the best option. So planning before the crisis, great. Keep in mind though, if you need care or your loved one needs care, it's not too late. We can still implement strategies to protect assets. We might not be able to protect them in the same way. We might not be able to protect as much, but there's still options. So pre-planning is so effective because it's preparing before the crisis. You actually have a lot more say at that time too. So if you're not in a crisis mode or somebody else isn't doing it on your behalf, you can have a lot more say about how you want things to look, or where you want things to go, or you can have more say in your care, where you might want to go as far as a facility or not want to go, or if you want that care at home, and planning for it ahead of time. All right, let's see, Landon, what's up next here? Let's talk about that 5-year look back. So there's a lot of misinformation out there, and part of why we offer these seminars is because we feel like it's so important to get everybody the information and the correct information. So the 5-year look back, what that is referring to, the 5 years prior to an admission into that skilled nursing home. So this all goes back to the Medicaid. And a lot of times, you know, people say, well, I'll never qualify for Medicaid. That's not necessarily true. Medicaid is an impoverishment program, but it doesn't necessarily mean you need to be impoverished, just impoverished on paper. So specifically in spousal situations, there's ways we can move assets between spouses and get you qualified for Medicaid immediately, even if you have substantial assets, whether it's money in bank accounts or real estate, investments, retirement accounts. But what's really important to know is, since we never know when the crisis is going to hit, we never know when you're going to need care, that as we get a little bit older, that we're making sure that if we are making gifts, we know what could happen when we need care. So you move into a skilled nursing home, or your loved one does, what they're going to ask you right away. First thing they're going to ask you is, have you made any gifts in the last 5 years? So gifts can look a little bit different. So Landon earlier talked about gifts of $15,000. And that is perfectly fine as long as we're dealing with federal regulations. But they look a lot different when we're dealing with nursing homes and Medicaid. A gift is anything over $500 a month. And that's a shock for most people, because most of us make gifts over $500 a month, whether it's to a charity or to our church, to our grandchildren or our children at Christmas or holidays, birthdays, weddings, whatever that may be. Most of us do that. And what I'm here to say is, it's okay. Don't worry. Don't feel like you can't make gifts. But there are some situations where you have to be a little bit more careful about it. And I'm going to give you some scenarios here. And actually, let's jump right into that, Landon. Thank you. Here's one we deal with a lot. So we want to gift our real estate. So we're talking about gifting. A gift is a gift. It's if you give it to a person, it's if you give it to an irrevocable trust. It doesn't matter. Anytime you give something away and don't receive fair consideration, it's a gift. So a lot of times we're dealing with real estate because that's a really important asset for us to protect. So let's say that we're giving your house away to let's say an irrevocable trust, because that's how we like to do our gifting, and Landon's going to talk a lot more about that today. So when we're giving the house away, the fair market value is $100,000. Within the next 5 years, so within 5 years of the gift, you need nursing home care. So we divide the value of the gift by the average cost of care in Pennsylvania, which right now is $10,732. And the state of Pennsylvania says, okay, you do not qualify for the state to pay for your care for 9.3 months. So let's say the only asset you've gifted in the last 5 years is your house. And you have enough, you will move into a nursing home and you have enough assets to pay for 9.3 months. That's great. That's fine. We just have to shift things around. We can get you qualified for Medicaid after that 9.3 months and make sure that we're protecting your house. But what happens if the only asset you had was your house, you gave it away to your child, and then you needed nursing home care? Your child says, well, mom or dad, that's it. I have your house. So then the nursing home is going to say, well, who's going to pay us now? The state's not going to pay for your care for the next 9 months. Your daughter, she's out. She's not going to pay for it. Now we have a situation. That's why it's really important to know how gifting actually works. That's where we get involved, and we do a lot of gifting. A lot of what we do, a lot of the pre-planning is gifting, but it's doing it strategically to make sure that we're not giving everything away, because even though we're sitting with you today and you're 60 years old and you're both in perfect health, we never know when that crisis is going to hit. We're going to hope and anticipate you get through the 5-year look back, but if you don't, we have to make sure we have a plan in place. So let's see here. So a question that we get asked very often, and this is all rolling into the 5-year look back, is, well, why can't I just give my house to my kid for $1, add my kids onto my account? So years ago, the strategy was, let's just deed our house over to our kids. And you can do that. I mean, legally, nobody can stop you from doing that, but it does bring up some questions and some potential issues. So we call them the 4 Ds: divorce, debt, disability, and death. So what happens if you give your house to your daughter and then she gets divorced? So then the house could be part of the divorce settlement. That's an even bigger issue if you're still living there. What happens if you give your house to your child and then they have creditors? They have some sort of debt. Well, then that house is part of their debt at that point in time. What happens if you give your house to your child and they become disabled? So then they may not be eligible for benefits because they have an asset at that point in time. And what happens if, unfortunately, you give your house to your child and they pass away before you? What does their will say? Do they have a will? What happens to that house at that point in time? So all of these concerns really drive into the next part of the conversation. And my section was real short and sweet because we're going to bump it right back over. And Landon's going to pick up and talk about the irrevocable trust. He's going to talk about some revocable trust too, but he's really going to focus on the irrevocable trust because that's really the asset that we use when we are protecting assets, because it's the one that works. So I'm sure you might have some questions or may have heard a lot of things about trust. So Landon, I know, is going to set the record straight now.
Thank you, Kristin. And I certainly hope I can speak up to those expectations. But so this is number 4 of the 4 considerations that we're covering today. So just to recap, we've covered the basics: your wills, powers of attorney. You should have those, and if you don't, you need to talk to me because you should have those. Second is special needs planning. If you have a loved one with special needs, there are things that would need to be considered there. 3, long-term care planning, very important. With the numbers that you saw with the costs, you can see how important that is and how much money can be saved if you plan correctly. Now, one theme that you've heard throughout all of that is trust. And this is one of my favorite topics to talk about. But to introduce the topic, I think it's very important to note that there are various different types of trusts. Saying the word trust by itself is no more descriptive than saying the word car. If you walk into a car lot and say, I'm here for a car, that doesn't mean anything to the person you're talking to because, well, do you want the nice Lamborghini there, or do you want a $1,000 car that barely runs? They're all cars. And so depending on what is the best fit for you is a question of your desires, your family, and your assets. And no plan necessarily works across the board. And so I introduced the topic this way because, especially after initial consultation, if I talk to you about things that we can do or what we might recommend, I have some people that might Google the word trust and then get confused. Because if you Google the word trust, you never know what you're going to get. It could be something that's relevant to you, or it could be something completely off the wall. And I'm going to touch the base. What I'm going to talk to mostly about today is the irrevocable trust that we use in asset protection planning. But just know that there are a lot out there. So for example, yesterday I gave a seminar for over an hour on one particular type of trust. Thankfully, we're not going to get into that today. Again, too much fun for our time today, but certainly I'll be glad to talk to you about it if you're interested. But so think about the trust and using that example as a car. So let's go with that example. A trust itself is a legal document that creates, for lack of a better way of putting it, an entity that can hold property. But if you just sign the document and you don't fund it, it has no value. So think of property or assets that you would put into the trust, like the gas for the car. Once you set up the trust, you can then move assets in there, but the trust has no effect until it's funded. And of course, like a car, it's not doing anyone any good unless there's a person to drive it. So with a trust, there is a trustee, which is the person that's in charge of managing the trust, like the driver of a car. That can be you or someone else. We'll talk about that, but the decision of who is the trustee is a very fact-intensive decision that depends on, again, your circumstances and your goals. So why would you establish a trust? Well, consistent with the long-term care planning plan, we're going to talk about that, but there's a lot of ways you could use it. One thing that is consistent across all types of trust is that they avoid probate. So probate is the process that when someone dies, the original copy of their will gets given to the courthouse, and you begin the formal estate administration probate process. Anything that's in a trust does not go through your will. So remember my discussion about will substitutes. This is another one that the trust says what happens to that property when you die. And that does not, and regardless of what your will says. But the probate avoidance means that when you pass away, whatever the trust says happens to those assets controls. And it doesn't have to go through the court probate process. It can be done internally just with your trustee and the law office working with you. And as I'll discuss later, an irrevocable trust can be used for long-term care protection because there are some strings in place to ensure that the trust separates you from the assets enough to protect them in case you ever had creditor or nursing home care issues that would otherwise have access to that money. You can use trust for controlled gifting. So if you want to pass on money to the next generation, but want there to be some restrictions or time frames or really anything that you would want besides just outright writing someone a check and hoping, praying that they don't abuse it, trust can be great for that. And then, of course, for federal estate tax, not a big deal right now. You don't hear much about that because as of right now, that affects only families, individuals that are worth more than $11.5 million. So if you are in that category, congratulations. There are things we can do, know that. But for the most of us, for the vast majority of everyone, we're not going to worry about federal estate tax. But with long-term care protection and then a beneficiary with supplemental or special needs, that's where trusts work for everyone, not just large asset families. There's a stigma out there that trusts are for rich people. Sure, they work for federal estate tax and things like that, but they can have great benefits for families of all, for assets and estates of all sizes and shapes. And it's just important that you speak with a knowledgeable professional about what would work best for you. And so getting into the types of trust, but not too far into it, I promise that I will spare you that. But there's revocable versus irrevocable, which if you think about the nature of those terms, that's pretty straightforward. A revocable trust is one that you are the person that set up the trust, you're the trustee. If you ever change your mind or want to change that, it is revocable in that you as the person that set it up can just get rid of it and empty it out and take everything that was in there. Those trusts are great for estate planning and for some federal estate issues, but they do not provide any protection whatsoever from nursing homes or creditors. If you want to talk about asset protection, we're talking about irrevocable trusts. And so as Kristin mentioned earlier, this is not about hiding, this is about protecting. And so where that protection comes from is that you have to give up some degree of control or access in order to get any sort of protection. An irrevocable trust cannot be just gotten rid of. If you say, you're working with me and Kristin and you decide that you want to go ahead and protect your house, the irrevocable part of it means that you can't just sign one paper and be able to sell your house and use that money to go on a big vacation to Europe. It belongs to the trust. And now we can give you a great deal of control and management. For example, you can be your own trustee, but in order to get some protection, there does have to be some degree of control and access that's given up. But we'll discuss in more detail how that looks and how close we can get you to that line. But again, in order to get that much benefit, there has to be something giving up. But that's what we'll discuss. Then within those, there's asset protection trust, special needs trusts. Those are subsets of the irrevocable trust, and the asset protection trust is the one that if you work with our office, you'll see them called protector trusts, but that is just a word that our office uses to describe it. But really what it is an irrevocable trust to protect assets. So got ahead of myself, but we got revocable versus irrevocable. And there's a few notes there on the screen as far as the different types of each. Again, I'll spare you the details of what all of that goes into. Just know that regardless of what your circumstances are, trusts are extremely customizable. As long as you know what you want, if you can describe it or even get close, we can help you formulate what you're thinking, and then I can craft a trust that will work the way you want it to work within the confines of the law, of course. But that's where a knowledgeable professional with specialized skills comes into play. But because a lot of these terms here are dealing with taxes, and unless you want to talk about taxes, which can be fun, we'll spare that for now. But know that it's very customizable. So let's talk about the advantages of transferring assets to a trust. Now, for purposes of this discussion, we are talking about an irrevocable trust. But the advantages of using this type of trust are that any assets held by that trust legally belong to the trust, meaning that they do not belong to you. So if a nursing home, for example, you go into a nursing home and they're asking what assets do you have, what they're really looking for is what assets would be considered countable or available to pay for care. Well, assets in an irrevocable trust do not belong to you. Therefore, they're not available to pay your creditors. Mm-hmm. The second note there talks about protected from a donor's estate for a recovery lien. So if everything works well at the pre-planning stage, if you need nursing home care and we're able to qualify you for Medicaid, they will continue paying your skilled nursing home care benefits. When you pass away, they will bill your estate for the amount of money that they paid on your behalf. But again, you don't own the assets in the trust. Your estate is your probate estate, meaning anything left in your name that would go through your will. Assets that are in a trust belong to the trust. They're not part of your estate. Therefore, they're not available to pay this recovery lien. And then also going back to the 4 Ds that Kristin talked about. Sure, you could just sign a deed to give your property to your child, but then that becomes their asset. So if any of these issues, the divorce, debt, disability, or death, if life happens to them, your house is now one of their assets. So yes, while you would get the benefit of you not owning the property in that scenario, they do own the property. A trust creates a separate entity from all of you, and the trust would own the property, not you, not your children. It's protected while you pass away, and then the trust can simply say that when you and your spouse die, the trust terminates, and then everything gets paid to your children. That way, it's the best of both worlds. You can use it and enjoy it while you're alive. It's protected from the cost of your nursing home care. Then when you pass away, everything still goes to your beneficiaries as you wanted to. And all the while, we've made sure that even if you need nursing home care, it's not jeopardized. So, of course, as I mentioned earlier, you can't get that many advantages without some disadvantages. Because, of course, if that would be the case, everyone would do it, and then the law would change, and then we'd have all kinds of stuff to deal with. You might be hearing from me in another seminar in that case. Wouldn't that be fun? Of course it would. So, so the disadvantages of doing that would be that you cannot withdraw the trust assets. Simply put, if you have the power to reach into a trust and grab whatever you want, then your creditors or your nursing home care providers could make you do that. So an irrevocable trust, an asset protection trust, takes that power away from you. And you can't just reach in there and use that money for fun money. Or in the example of a real estate, if you were to sell the real estate, you can buy new real estate in the trust, but you can't take out $20,000 to go on your dream European vacation. Now, the most important part of that, of what I said there, is that you can't do that. In our trust, we create a role called the trust protectors. Now, note that this is different than the trustee. You can be your own trustee because the trustee manages the assets that are in the trust while they're in the trust. But again, that protection comes from the trustee not being able to give assets to you. The trust protector, their sole job is that if needed, they do have access to pull money out of the trust. A lot of times this ends up being my client's children, because the children can be a beneficiary of the trust. So using my example of the real estate, you sell it, you still want to go on your dream European vacation. Your trust protectors can pull money out of the trust, but it has to go to one of the children. Once it's in your children's name, they can do with it as they wish. But what we want to avoid is it going into your name, and we never want assets ever going directly from a trust to you. And that's where that's the disadvantages. But again, with the trust protector, as long as you have someone that you trust to stay in that role, there are ways to still ensure that you're not completely divested of the assets. So I guess the conclusion of this talk is that having the right tools in your estate planning toolkit makes all the difference. And I'm sure that Kristin and I could find files that are the best case scenario and the worst case scenario. And the amount of money spent between those two files is outrageous. Mm-hmm. This is a very individualized practice, and it really takes individual consultation and time with you getting to know your family and your assets to ensure that we can get the best outcome for you. But then having the best tools in there can really provide a immeasurable benefit down the line as you prepare for the second half of life. So at our office, as Kristin mentioned, we do free initial consultations. We have a team of attorneys, certified long-term care planners like Kristin, and then a very good and knowledgeable staff that specialize in this area of law and can make sure that you get an individual plan that works for you and your family. One of the best ways I've put it to my clients is that we offer peace of mind, because people think about these things all the time, especially if someone gets sick. the questions of what happens next are things that get caught up in people's minds. And there's a lot of peace of mind in knowing that there's a plan in place. Regardless of what happens, you have a trusted team behind you that can make sure that there is a plan that can be put in place. Mm-hmm. And so even though with COVID-19, we're mostly green now, so things are laxed a little bit. We've been open, even in the midst of it all. We're doing a lot more remote consultations right now, but don't hesitate to call, because by being on this seminar right now, you've been introduced to Zoom technology, so we can still meet face-to-face. I just can't shake your hand, which is one loss I've had during all this. Very sad about that, but we can still absolutely help you out to get a plan in place for you. And then, with us all being in green right now, we are able to still do quick signing appointments, but we are keeping all precautions in place to ensure that our office is a safe environment. So we would do, I'm meeting with clients via Zoom or telephone all the time to review documents, but then once I get the okay that they're ready to sign, we can do quick in-office signing appointments to make sure that things move along. And again, with those precautions, we are still requiring masks. We're practicing social distancing, and anything touched by a client, whether it's tables, chairs, everything that comes into contact with people is being sanitized between every client, so that you know that you can be safe even if we do need to meet face-to-face. All right, and just know that we're here for you. And if you have any questions, we're going to stick around and answer any questions that you do have. But know that we're still open and we're here for you, so don't hesitate to give us a call. Thank you very much.